And the court in both Dolm and Brokamp held that the statute of limitations that applies to refund statute cases is jurisdictional. The language in 7422A is virtually identical to the language in 7421.
That is correct, although in the refund context you have the sovereign immunity problem in which we presume that has not been waived.
Right, but 7421
and
7422 were the same, and originally they were the same statutory provision. They were only separated out later. So I do think that's the strongest textual indication, Justice Ginsburg, that 7421A is jurisdictional.
The question that I asked you is, if you're right that this penalty is not covered by Section 7421, if you're right about that, why should we deal with the jurisdictional question at all? Because this statute, correct the way you read it, doesn't involve a tax that's subject to the Anti-Injunction Act.
Yes, that is exactly our position. And the reason we don't...
So you agree that we would not, if we agree with you about the correct interpretation of the statute, we need not decide the jurisdiction.
There would be no reason to decide the jurisdiction.
Don't you want to know the answer?
Justice Kennedy, I think we all want to know the answer to a lot of things in this case. But I do think that the prudent course here is to construe the statute in the manner that we read it.
Well, but you indicated, there was a discussion earlier about why does the government really care? They have competent attorneys, et cetera. And you began your argument by saying it would be very troubling to say that it's not jurisdictional. I'd like you to comment on that. It's not for us to tell a party what's in its best interest. It would seem to me that there might be some instances in which the government would want to litigate the validity of a tax right away and would want to waive. But you say that's not true, that it's very troubling.
I think there are two problems. One is the problem that Justice Scalia identified, that if it's not jurisdictional, then courts have authority to craft equitable exceptions, and it may seem from where we stand now that authority is or could be very, very tightly cabined, but it will, if this court were to conclude that it isn't jurisdictional, that does empower courts to find other circumstances in which they might find it equitable to allow cases to go forward in the absence of, despite the existence of the Anti-Injunction Act. And second, although I'm certainly not going to stand up here and disparage the attorneys for the United States in the slightest, the reality is that if this isn't jurisdictional, then it's open to the argument that it's subject to forfeiture by a simple omission and failing to raise it in an answer, and that's a troubling prospect.
How likely is it? I mean, the government is going to be defending these suits. How likely is it that the government will overlook the Anti-Injunction Act? So it seems to me that this is arming the government by saying it's waivable at the government's option.
That is not our assessment of the institutional interests of the United States, Justice Ginsburg, and we do think that the right way to go in this case is to read the statute as not applying to the minimum coverage provision of the Affordable Care Act.
It was the calculation of the interests of the United States that your predecessor made in the Davis case. There, the Solicitor General exercised authority that we sanctioned to waive the Anti-Injunction Act. And, of course, that couldn't be done if it were jurisdictional.
That's true, Mr. Chief Justice. Several points about that, though. We do agree with Mr. Long's analysis that Davis occurred during a time in which, under the Standard Nut case, the Court had interpreted the Anti-Injunction Act as doing no more than codifying the traditional equitable principles, which allowed courts discretion to conclude that in certain circumstances a case could go forward. Williams Packing repudiated that analysis, and Bob Jones against Simon, again, repudiated that analysis and said, no, we're no longer abiding by that. It is true that the Davis case has not formally been overruled, but we do think it's fundamentally inconsistent with the Court's understanding.
Davis was the case that where a shareholder sues the corporation.
Yes.
And the remedy is that the corporation shouldn't pay the money to the tax authority. Now, it's a little technical, but that isn't actually an injunction against the tax authority collecting. They're not restraining the collection of the tax. They're saying to the taxpayer, don't pay it.
Yes. And
I don't know how far that gets you.
Well, in fairness, Justice Breyer, the United States did intervene in the Davis case and was a party, and so not as far as I'd like, I guess, is the answer.
Don't do it again, because I think that goes too far. I
well,
don't think that's restraining the collection of a tax. It's restraining the payment of the tax.
Well,
But you don't want to let that bone go, right?
our view here is that it is jurisdictional. Because it's jurisdictional, as this Court understands jurisdiction now, it's not waivable, and therefore we don't think that that part of the Davis decision is good law.
General, can I ask you about Reed Elsevier? Justice Ginsburg suggested that the language was very similar in Reed Elsevier as it is here, but there are even further similarities. Reed Elsevier pointed out that the provision in question wasn't in Title 28. Here, too, it's not in Title 28. In Reed Elsevier, it was pointed out that the provision there had numerous exceptions to it. Here, too, there are numerous exceptions that we find that have been created by the courts over the years. In Reed Elsevier, the question was essentially one about timing. Come to court after you file your registration. Here, too, the question is one about timing. Come to court after you pay your taxes. So Reed Elsevier seems in multiple respects on all fours with this case. Why is that wrong?
I don't think so, Justice Kagan. First, we think, I guess I'm repeating myself and I apologize, but we think the closest analog is the very next provision in the United States Code, 7422A, which this Court has held as jurisdictional and is phrased in exactly the same way as 7421A. In fact, as I said, they were the same provision back in the earlier days. That's the closest analog. This isn't, and it's actually 7422 that's the statute that says do something first. But this statute is just a flat-out command that no suit shall be maintained to restrain.
I take the point, but if you would comment on the similarities of Reed Elsevier to this case, how do you think it's different at all?
Well, because I think the best answer to that is that there are no magic words, and that history and context matter, as the Court said in Henderson. And the history and context here is that 7422 and 7421 function together to protect an exceedingly strong interest that the Court has held with respect to 7422, sufficiently strong that it explains the jurisdictional nature of that. Same interest applies here. This isn't just a matter of do X and then you can come to court. It's just a fundamentally different set of interests at stake. So we do think that makes a big difference. And,
why isn't Reed Elsevier, if you're dividing jurisdiction from claims processing, says you have to register before you can sue? There are a lot of things you have to do before you can sue. So why isn't Reed Elsevier like you have to pay a filing fee before you can file a complaint?
it is. We do think it's very much in that nature and different from this case, Your Honor. And one way I think it's helpful to get at this is to look at the history. We've cited a string of Court of Appeals cases in a footnote in our opening brief, and over time it's been very consistent that the Courts of Appeals have treated the Anti-Injunction Act as a jurisdictional provision. Again, if the Court agrees with our statutory construction, we don't need to reach this issue, but they haven't. In fact, one of those cases, the Hansen case, the district court in that case had dismissed the complaint under Federal Rule of Civil Procedure 12b-6. The Court of Appeals vacated and sent it back with instructions to dismiss under 12b-1, which is the subject matter jurisdiction provision. So I do think that to the extent this issue is before the Court, it is jurisdictional, but it doesn't need to be before the Court because of the statutory construction argument.
On your statutory construction argument, is there any other exaction imposed under the Internal Revenue Code that would not qualify as a tax for Anti-Injunction Act purposes, or is 5008 just out there all by itself?
It's not quite out there all by itself. There are other provisions that fall outside of subchapter B of Chapter 68 and therefore wouldn't be governed by the instruction in Section 6671A, which answers the question about the applicability of the Act for most penalties. The ones that we've identified, I may be overlapping a little bit with Mr. Long here. One is 26 U.S.C. 857, which poses certain penalties in connection with the administration of real estate investment trusts. There are provisions that Mr. Long identified in his brief, sections 6038A through C of the Code, which impose certain penalties with respect to reporting requirements for foreign corporations. We have, in addition, in footnote 22 at page 36 of our brief, identified 3 provisions that Mr. Long also identified about alcohol and tobacco. Now,
could we address, General, the question of whether there are any collateral consequences for the failure to not buy health insurance? Is the only consequence the payment of the penalty? The private respondents argue that there are other collateral consequences, such as for people on probation who are disobeying the law. If they don't buy health insurance, they'd be disobeying the law and could be subject to having their supervised release revoked.
Yes, that is not a correct reading of the statute, Justice Sotomayor. The only consequence that ensues is the tax penalty. And we have made a representation, and it was a carefully made representation in our brief, that it is the interpretation of the agencies charged with interpreting this statute, the Treasury Department and the Department of Health and Human Services, that there is no other consequence apart from the tax penalty. And I do think, if I could talk for a couple of minutes about the argument that was discussed as to whether this can be conceived of as a suit just challenging the requirement, which is entirely standalone based on inferences drawn from the exemptions. We really don't think that's right, and if I could spend a minute on it, I think it's important. The exemptions in Section 5000A, it is true that there are 2 categories of exemptions. There are exemptions to the penalty and exemptions to the subsection A requirement. But I think, not only as a practical matter, but I think there's a textual indication that even as a legal matter, they both function as exceptions to the requirement. Now, first, as a practical matter, one of those exemptions is a hardship exemption, and if the Court will just bear with me for 1 minute here, it's at page 11A of the appendix to our brief. It provides that a person can go to the Secretary of HHS and obtain a hardship exemption which would, as a formal matter here, excuse compliance with the penalty. It seems to me to make very little sense to say that someone who has gone to an official of the United States and obtained an exemption would nonetheless be in the position of being a lawbreaker. We think another way in which you can get to the same conclusion slightly differently is by considering the provision on the prior page, 10A, which is 5000A E sub 3, members of Indian tribes.